Thanks for joining us once again on this anti-SGBV series. We are Pamoja CPO, and today we'll be discussing Kenyan legislation that has been passed over the past 23 years that protects survivors of sexual and gender-based violence. As a reminder, 13% of women and girls in Kenya have experienced acts of SGBV. In 2001, the Children's Act was passed and contains sections that demand protections from abuse and harmful cultural practices, including female genital mutilation, as well as designation of children's courts for court proceedings that include children. In 2006, the Sexual Offences Act became law, which provided standardized definitions for sexual acts including sexual assault, rape, defilement, prostitution, and others. Additionally, this act created a national policy framework as well as mandated punishment for perpetrators and medical treatment for all survivors. In 2011, the prohibition of female genital mutilation was passed and was followed in 2019 by a national policy on the eradication of FGM to enforce an end to this cultural practice. In 2014, 3 acts, that is the Marriage Act, the Victim Protection Act, and the National Policy for Prevention and Responses to Gender-Based Violence were passed to protect survivors of SGBV. In 2019, a multi-sector standard operating procedure for prevention and response to gender-based violence was released. Each of these acts, laws, and national policies provide protection for survivors of SGBV, as well as providing medical treatment free of charge. However, gaps remain in the implementation of these laws, leading to the continuation of high rates of SGBV in Kisumu and Kenya as a whole. Let us know what gaps you see in your existing community in the comments. Join us later this week to learn more about international legislation that Kenya is a member state of. And remember, if you see something, say something.